So our next guest is attorney Patrick Schilken, and he's going to be talking about the new Colorado law, Senate Bill 2458, Power Trail Statute, Motor Vehicle Use Map, and how and who it affects. So Patrick, welcome.
Thank you, Kim. I really appreciate it. Thank you all. My name is Patrick Schilken. I'm an attorney that's based out of Denver, Colorado, but my client base is all over the four corners of the state. And my real kind of practice area is in, of all places, probate and trust. And they're wondering, well, how could someone like me that has this very narrow application and practice of the law have any interest in this? But in a lot of the cases I participate in, land issues always come up in a variety of different ways, of anything from mining claims, ranching, farming, mineral rights, water rights, you name it. And I've been buried deep in this stuff now for over 30 years. And one day, which I will cover later on in my slide presentation, came that moment that I think Joshua explained, that your rights suddenly disappear. And that happened to me. And so since that time, I have become a very strong advocate from a private landowner's perspective on some of the things that you will see that are going on in the state of Colorado. And one of those is kind of sort of what I faced probably about 10 years ago, was I own a pretty sizable chunk of mining claims out of Park County, Colorado, and coming across a couple from the state of Georgia that appeared to be very lost and was very late in the afternoon. And I approached them. I said, you do know that you're on private lands. Where did you come from? And they go, we don't know. We came off of that mountain over there, which happens to be Mount Sherman. We read in our little handout that we could climb this mountain in a day. And I looked at them and I said, do you see those black clouds that are starting to form over that range? You all are in a lot of trouble. You can't go back to the top of the mountain. You can't go to the south of you because that is a cliff. And the only way is I need to get you out of here, because in about 5 minutes, all hell is going to break loose up here and we got to get you off the mountain. And that is just one of many instances where I've run into people out enjoying the wilderness, because the state of Colorado, we are a state where private land ownership, public land ownership, and tribal ownership, we are in the top 10, but we are clearly not the only state that is affected by this mixture of ownership. And this is an important thing, because when I begin to start to talk about this, is that 65% of our state is owned by either BLM, Forest Service, or some other governmental entity. Whereas private land ownership of our state has really been about between 30 and 33% over the last several years. So I want to illustrate this with something that many of you may not have seen, is mining districts. And mining districts are a special creature under both federal and state law. And this happens to be one of the more famous maps of the Leadville mining district from 1901, where you can see the incredible overlay of private lands interfering and also intersecting with federal lands. And if you go on to this next slide, when we drill down on that map, what I want to show everybody is these areas right here and right there, sandwiched in all of this private patented mining claim land, is federal property. And it makes it near difficult for us that own in these areas to be able to discern what is private and what is public. And so when you start to look at the settings of these kinds of areas, and there's over probably 150 mining districts in the state of Colorado, a lot of this is unfenced. We run into quite a few people that are up there enjoying federal public lands, because Colorado is a major tourist destination, and the economic numbers bear out. Where we are receiving in the state of Colorado, and please understand, this comes from a 2017 study of how much money filters into this state through economic tourism. This is pushing a lot of what we're seeing, both in the public sector as well as the private sector is this massive kind of sort of shift in our economic base of going from both a mixture of industry, agriculture, service, to becoming one of the top destinations in this country for tourism. I am here to really cover from the private landowner's perspective 3 statutes that I had a great deal of influence on. Colorado Recreational Use Statute, what is known as Power Line Trails, and this acronym of MVUM, where my journey really started over 10 years ago. Recreational use statutes have been around this country for quite some time. And what it basically boiled down to is the encouragement of private landowners opening up their land for public use. And when we went in and studied this, I mean, some of these statutes go back into probably the early 70s, and where our statute kind of was based on is the Colorado Ski Safety Act of 1970. But the big thing is allowing to use for public purposes if no fee is charged, and there is, and this is a really, really important term here, malicious intent on part of the landowner to injure the recreational user. Part of this really stems from the old spring gun cases where private landowners were trying to protect their land and using things like spring guns to take care of intruders onto their private property. So what they did is to say, listen, as long as you are not out setting bear traps, pits, using any sort of guns, we're okay with that. You will not, if someone's injured on your land, then we're not going to pursue this. However, in 2004, and this is how long it took us to get this statute up and running, the statute has an exception in Colorado. If an injured party can prove that the landowner willfully failed to warn or guard, recreational visitors about a known dangerous condition to likely cause harm. Well, that is a whole different standard than malicious intent. That means that I'm on my property, I see a known dangerous condition, and I fail to warn the recreational user, the hiker, the biker, whatever that person may be, that this condition does exist. This is a very typical mine shaft that is in the mountain area. This happens to be on one of my parcels. In fact, I've dropped a rock down in there and have never heard it hit. Wouldn't you think, in my opinion, that is open, that is notorious, that you should avoid, that you should not stand over or look in, or in a video that was published about 10 years ago, dangle your child over to tell the child, what do you see down below? Then came a very famous case. In 2008, Mr. Nelson was riding his bike at the Air Force Academy along one of their trails. He had fallen into a crevice or a sinkhole that had opened up on the trail that apparently was shaded by a tree. Although I got to tell you, I've heard different facts on this, but let's just go with the shaded by the tree part. Was severely injured, and less than 2 weeks before this injury, a biologist had shown up at the Air Force Academy to study all of their trails, their biological systems on the Air Force Academy, filed a report with the Air Force Academy saying, hey, there's a problem out there. You all need to address it. The trial court had denied this under CRUS, saying that the Air Force Academy did not willfully ignore the hole. They were dealing with it. They were trying to fix it. But what else came out in the 10th Circuit is that the Court of Appeals ruled that the Air Force Academy knew. Remember, in the first part of that statute was willful. Knew. Okay, willful means I am actually knowing of it, failing to take action, that the washed out section of the paved bike trail, but failed to give proper warning. Guess what that ended up being? Mr. Nelson was awarded $7.5 million. In 2019, two of us, not a whole group of us, but two of us got together and said, we can't have this. We cannot be landowners knowing what we know about our land, knowing where we know the hills are, where we know the pitfalls are, where we know the land is subsiding, and we've got to do something. So two of us, John Reiber, who happens to be a landowner that owns the tops of Mount Lincoln, Democrat Bross, who has hiker problems all the time, approached our legislature and said, we need to make a change to this. I know that there are dangerous conditions on my land. There's a big hole there. Am I required to warn somebody that don't go in the hole? Don't dangle your child over it. Don't stand next to the hole. Don't try to rappel down the hole. Don't try to take videos while you're rappelling down the hole. But apparently the legislature felt very different. No, Mr. Schilken, you need to warn against an obvious known condition. The first rendition of this bill we completed in 2023, presented it to the Senate Judiciary Committee, and the attorney that represented Mr. Nelson stood up and made a very interesting comment. The comment is, as best as I could remember, encapsulated down below, that landowners have nearly, I love when lawyers use nearly, it depends, kind of wishy-washy language, complete immunity, because the exception bar is quite high. Okay, keep that in mind as I go on. It would be very difficult for any claimant or plaintiff to address. A landowner who is concerned about steep cliffs, extant mine works, can easily warn. That went to the Senate committee of the Judiciary Committee, and the Judiciary Committee had rejected our first rendition of the bill in 2023 because we could easily warn people, stay away from a cliff, stay away from a hole, stay away from equipment, stay away from bison, stay away from cattle. So when I presented this slide, was one of my mining claims in Park County, I then asked them, where would you propose that I put these warning signs? I'm telling you right now, having stood at the bottom of some of these workings, that is a vertical cliff right there. But you'll notice the nice rolling part above it. I have not caught anybody in this area, but I do know that people have attempted to try to go into some of those crevices. Am I supposed to post signs anywhere up here that you could be in danger if you go over this edge? So, landowners need to be aware. Let's see what we can do. We do have a statute that allows us to not open our plans for public recreation. But we must follow the no trespassing guidelines to be able to accomplish that. Or, under finally the bill that we did get passed, we can open our lands for public use. I don't know how many of you have seen this. This is statute right now on what we need to do with trespassing in the state of Colorado. My land is not fenced. And you can see that some of that would be nearly impossible for us to do. But if it is fenced, it's considered to be a barrier against people entering land. But for people like me, fencing it would be near impossible. And I must provide notice that if they are crossing there, it is trespassing. But here's the big part of this, is that my signs must be posted at 440 yards or at a ready identifiable entrance. So for any of you that have private lands that want to keep people out of it, you have to post signs. We have tried to work on this part to say we have wonderful technology. Signage either is usually stolen, usually shot up, usually knocked down, and left to the side where it can't be viewed. One of my properties, I do have a main entrance where we have it gated and a sign is posted, but the rest of it is still open. because I also happen to be along a very important wildlife corridor as well, too. So that would begin to cause problems if I were to erect a fence. Colorado wildlife statutes very clearly state that you cannot take game or hunt on private lands without getting permission. One would think that should probably be the way that things should be set up. But it applies to people that have licenses and that are hunting, and you must get permission from the landowner to be on that land. I just throw this in here because I happen to be a mine owner, that I have a duty to secure my property, post no trespassing signs, warn people. However, as you can see, that can be rather difficult for me. One of the problems that I've run into is under the Division of Mining and Reclamation, abandoned mines. I put my name on that list over 12 years ago, and to this day have never gotten a response to go back up into that area and help us at least cover some of this stuff. Again, I put this in here because this is a growing problem for us private landowners, is that people come to this state, transplants otherwise, and start stealing our survey markers. And then these survey markers magically appear on eBay and other sites where they're being sold. This is a very typical mining land marker that's been chiseled into rock. And in fact, I heard a rumor that there's a gentleman up in Park County that has taken a bunch of these and built his lovely rock fireplace out of all these stones. And for those of you, this happens to be also a marker for unpatented mining claims. So what happened? We tried our first go around in 2023 to get revisions to the statute. We were rejected. And then along came Senate Bill 2458. That came after some hard negotiations with the Colorado Trial Lawyers Association that we have got to still fix this problem. And coupled with John Reiber closing down the peaks, the DeCalibron Loop. And that got everyone's attention. During high point of hiking and access season, no access to 4 of the 14,000-foot peaks. And finally, everybody got together, gathered around a table, and started working on this very important piece of legislation. Approved by the governor on March 15, 2024, was just recently effective in August. But one of the things that we had to overcome is this willful or malicious part of this statute. We really begged the Colorado Trial Lawyers Association to please step up and make changes to this. Most of us that own private land are not there maliciously or willfully failing to warn people. It just becomes hard, becomes difficult, signage missing, signage is stolen, signage is taken down or shot up. So if you want to open your lands to recreational use, the following must be accomplished. A sign can either have a vertical or horizontal, but it must be posted in a location that makes the sign visible to an individual at the primary access point, meaning that this is the part of the land that is available you to enter or cross or participate in. And can't post it after somebody's been injured or dead, but prior to death or injury, the owner must maintain photographic evidence that the sign was posted or evidence otherwise that the sign was posted. And the dangerous condition, use, or structure of the activity that caused the injury is described by the sign. All 3 must exist. And there's your sign. Now, I don't know how many of you have had signs printed before. It's a little hard because this is a dissertation, in my opinion, but it at least gets across that if you enter this private land, you're not going to hold me, the landowner, liable for any of these conditions. And I think this is an important part of this. And if I open and obvious. It takes care of a big concern for us where we have had just absolute abhorrent negligence on behalf of the recreational crowd on claiming that we didn't know the terrain. How many of you are aware of the gentleman that took his four-wheel drive up the Lincoln Trail and tried to navigate across the screed field? And it took over 2 days to get he and his truck extracted off of the side of that mountain. That's the stuff we face. Now, he destroyed a lot of the land up there, destroyed a lot of the private land up there. They had to eventually get some specialized tractor up there to get him out. But he said, I didn't know it was going to be so steep. I didn't know that I couldn't take this truck out there on a off-camber maneuver of exceeding 40%. But that is what we face. I just happened to throw in here the definition of land. Includes a whole bunch of things. And I also want to think, I don't know if I've got it on this slide or the next one, actions against landowners. Yes, conservation easements. It also has some unintended consequences as well, too. Not only does it dictate a little bit about what you can do with your land, but now you become a landowner that can grant permission for the public to enter your land. That was a part of the statute we argued very heavily about including, because unless your conservation easement reserves the recreational use back to the landowner, that land is technically open for them to grant permission for the public to enter your land. I encourage anybody that has a conservation easement to please sit down and read through it. I'm astounded when I get these documents. Yes, they're long. Yes, they're complicated. But read it, because in those documents contains your rights to reuse your land. And many times, conservation easements also give away the recreational rights as well, too. Power line trails. Has anybody heard of this? So, this was a piece of legislation I gave public comment on. I was very concerned because of one thing and one thing only, is this thing called transmission corridors, where a tract of land owned, occupied, or leased by easement or right-of-way held by a transmission provider. Now, granted, those voltage lines have to be over 69,000 volts or more. But what it does, it opens up utility easements for public access. 3 of us had given testimony to the Transportation and Energy Committees about this legislation. We had raised concerns that many of these power lines cut across pastures, cut across mountain terrain, cut across all kinds of areas that really people should not be in. The good news of this, and I really want to point this out, is when we get into the rural character and the rural nature of our state, any power line transmission organization or power line utility easements must take in issues of grazing, wildlife impacts, and more importantly, the potential liability of the public on private lands where private lands adjoin the easement. I think after our testimony to get these 3 points in there, and I mean, I don't care for the legislation, please don't get me wrong on this, but at least we've got an ability for local government to step in and say, not so fast. Does anybody know what this is? Blue Ribbon Coalition should know this. They're on the lawsuit that I clearly support. What is this? This is my introduction as a private landowner to this thing called the Motor Vehicle Use Map. This is a map that is required by BLM and Forest Service to outline motorized vehicle trails through all of our national forests, BLM land. shows us what can go on the land, what can't go on the land. And my daughter and I were about ready to do our duty as mining claim owners to go up and inspect everything, park in our usual parking area in the Forest Service, and lo and behold, there's a huge gate in front of us that says road closed. Brand new. Never even saw this gate before. For the 10 years I've been using that same road, that gate never appeared. And I said to my daughter, well, what is this? So we packed up the ATVs, all of our equipment, because we need to go up and do some work, drove over to the Forest Service office and said, why is there a gate in front of Forest Road 486? And he goes, well, as a Forest Service, we've failed to update our map. And it says right there, shall be updated annually in January. We got sued by Colorado Wild, Old Broads for the West, and several other environmental organizations that we failed to follow our own rules. So in order to comply with the lawsuit, we shut everything down. I then jumped into action and very smartly went out and requested a Forest Service permit for access. It's the only one that's been granted up there in the last 5 years, and I'm at least not locked out. But my neighbors didn't care for that because I won't let them use that either. I should have probably asked before I went out and got all that done. But this map is that. Every single Forest Service, north, south, east, west, BLM, must provide a map every single year. And I wish there was a better picture of this. This is for free, by the way, of what's open and what's closed, what's seasonally open and what's seasonally closed. And for some of us that have private lands in very remote areas in the Forest Service, this is our access. I'll give you two resources that I think are imperative that every single person who is out experiencing our great public lands is Avenza Maps. You are able to download any of those MVUM maps for free. They should be on your phone. And who's ever heard of the Cotrex? One person. Two. I think this is the key to continue to monitor access to our public lands. It works in all conditions. It is a satellite-based program, will appear on your phone. It gives you all the trail descriptors, all the restrictions, everything you need to know. Because without this information, you're really lost out there. Yes, I also have Onyx Hunt, Onyx Off-Road. I do use those other programs. I like free stuff, and I like stuff that's current. After getting my permit, I decided that it was time to become active and to step in and start to really pursue this as a private landowner. Yes, there are groups out there I could have joined. There are groups that are out there providing access to our public lands. But as a private landowner, I felt I had a unique position that I am a stakeholder. I could represent myself as a stakeholder, and I can have a seat at the table. Because when you start cutting off my access, you are interfering with my right to own lands in the state of Colorado. I point out the Federal Register, and that is an important communication device for anybody seeking information about what's going on with all aspects of BLM, Forest Service, and other agencies. Yes, this is a difficult thing to navigate, but it actually is extremely important for activists to know that meetings, deadlines, what needs to be, what is being done, what is not being done, all of those things are all contained within the Federal Register. And procedures. Yes, I am an attorney. I'm very well aware of procedures, very well aware of what you can and cannot say. But I will tell you, if you're prepared, because the other opposition is very well prepared. They're very well funded. They have lawyers, they have law firms, they have people that support them. And so I learned the hard way of how to proceed and provide competent public comment. And over the several years I've been doing this, at least I still have a seat at the table, and that's where you want to be. The nice thing about it is that your information usually can be not identified. If you so wish, for me, it's important that they do know who I am, but I just want to let everybody know that if you wish to not be identified, you can certainly have that. And just in case anybody did not know, our BLM office is now located out at the Federal Center in Lakewood, Colorado. Anybody that is doing any sort of federal research, any sort of land use research needs to be aware that this is where the office is located, and this is the phone number and how you can get a hold of somebody. I want to thank everybody. I know this is a little bit off the beaten path, but I think as a private landowner that is clearly woven into the fabric of federal lands, as a Colorado resident, you need to be aware that our state is really being overtaken by tourism in huge, huge fashion. We cannot lose sight of the fact that we have to make sure that that doesn't get out of control to the point where it impacts private land ownership. Thank you very much. I really appreciate it.
Did you want to take some questions?
Yeah. Anybody? Yeah, Kim.
Clarify, I'm not president of the Colorado Union of Taxpayers. I'm president of the Colorado Union of Taxpayers. There we go.
Yes.
I have a volunteer gig also that I'm president of the Colorado Union of Taxpayers, where we watch all this legislation that is proposed each legislative session. So just clarify, I remember seeing this Senate Bill 2458.
Yes.
I didn't quite understand it. Mark Baisley.
Yes, Mark Baisley was our senator representative that sponsored
So just clarify that for me so I understand it a little bit better, please.
His involvement in it, or was it?
What it did exactly.
Okay, so what it did is under the previous statute from 2004, is it left kind of an open part of the so-called immunity of you willfully failed to warn. Now, malicious was always the old standard. That I had set up a trap. I had done something maliciously with an evil heart to thwart people trespassing on my land. Colorado deviated from that and used willfully failed to warn. Then when we went to Amy Mitchell, who is a Park County commissioner, had turned us on to Mark Baisley, who has a passion for this, and helped us take the bill forward to say, listen, most of us don't have the resources to go out, many landowners, and put up warning signs. Those signs are really expensive. Is there any way that we can come up with standard language that every landowner could use to warn against conditions on the land? And that gets us around the willful intent to create harm. See, the thing that bothers me about the Nelson case is that he fell into a hole that was discovered by the Air Force Academy. They were not ignoring it. They were just trying to figure out how to fix it. And then this guy was injured, and then it came in, well, you knew about it and failed to warn Mr. Nelson that he was going to get injured. Well, wait a minute. I know there's a big hole up on my property. Do I have to put a big sign up there? Stay away. Don't dangle your child over the hole. So my take is, Kim, is that really opened up. Now, granted, CTLA, Colorado Trial Lawyers Association, said, you're just overreacting. That's what we were told. You're fear-mongering. You're putting all this fear out there that this is going to happen. Sir, have you been up there? Do you know what it's like when you leave the limits and go up into the high country and see what's going on with these folks? Anything's possible. So that was the thing, Kim, that we really wanted to focus on, is how do we get a workaround of that willfully knowing? I go up and inspect my property. Do I have a duty to do that? Well, as a mine owner, yeah, I kind of do. But do I have the right can I just ignore, like, wow, that is about ready to cave in? And to know that most of the signs I post up there are gone anyways, along with all my rocks. So thank you, Kim. Oh. Have anything they have a burning desire to know?
I have a question.
Yeah.
A friend of mine has a GPS unit for when he's going hunting.
Yes.
It says on his GPS that the location of my house is a conservation area, San Luis Valley conservation area. And when I confronted the BLM about that, they said, "Oh well, sometimes these GPS companies make mistakes." Of course, I raised an eyebrow to that.
Yes.
I don't believe that as far as I can tell. I think that they're trying to put designations even onto private land, and honestly, I don't think I think they're using that as another method to attain the 30 by 30 initiative.
Thank you, Joshua. Yes. I mean, let's face it. I had a situation on one of my claims where there was a gap between two of the claims. And Colorado Parks and Wildlife have always said that that was an easement. And it was an access to an area beyond my property. I've now spent probably 2 years in fighting that to close that gap between those claims. I started off at a very localized level, which was our local clerk and recorder and our assessor, and went ahead and had them change all of their GPS mapping, because a lot of that stuff either comes through the Department of Agriculture or locally. I think it is imperative when you get into these situations is to not give up and continue to push this. Because to your point, if there is a gap or there is some sort of thing, because everybody that is a private property owner should know what they own, where their pins are located, I can't tell you how many times I meet with a client. They have no idea where their survey markers are. They have no idea that their road may be intrusive on either public lands or private property. Those problems are hard to fix. But you got to keep vigilant. You've got to make it known that these maps are not incorrect. The hardest one I've had the problem with, Joshua, has been Onyx. I can't tell you how many times I've called their office and said, you have to correct your maps. You can't tell people that this corridor is an easement because it is not. You can't continue to send people there telling them that it's perfectly okay to walk this area because it is not. So you have to stay vigilant. And I'm hoping in the next couple of meetings I have with Onyx is to maybe try to get some of that fixed. But you have to be aware. You have to be looking at this. You have to be questioning it. And you have to bring it to whatever official is available for you to bring that to. But yeah, I would say that if you don't, then you not necessarily acquiesce, because GIS systems, GPS systems are not considered official just yet. But I'll tell you, my Montana 600 now puts me within 2 feet of my stakes. Used to be 30 feet under the first GoTrax handheld devices, but now it's within 2. And if you stand there long enough and let the satellites reorient it, you're pretty much spot on to where those markers are located. So it's important to take the initiative to continue to bring forth those kinds of problems. Yes, sir. Uh-oh. What rabbit hole are we heading down?
Our property is a home. We're completely surrounded by BLM.
Yep.
Access to our home is on BLM. The BLM charges me a gracious fee every year. It goes up every year.
3% per year. Yes, there's, yep.
Like right now, we pay $1,000 a year to get to my house, 2 miles from BLM. What's our stipulation for that? How are we going to address the constant fight? I mean, by the time my grandkids are grown, it'll be $8,000 a year.
So thank you, because that exact same situation I face, my first fee for my access to one of my claims started off at being $225 a year. Now, over the past 5 years, it's gone up to around $500. I will not be much further behind you. So what we have looked at, sir, is two very important acts. I'll admit to you that I am not as versed in this area, but it begins with researching RS 2477. Now, RS 2477 deals with pre-Forest Service and BLM lands or roadways that went through those areas. And what those say is that if those roads existed prior to 1912, because that is officially when BLM and Forest Service basically started, those lands may be exempt from that very thing that you have. I was also told that there is the Alaskan Lands Act that has verbiage in there that has a tendency to support open lands that you don't have to have a permit on. The problem what happened to me is that my area before my gate was declared a wilderness area. And I never received notice of any of this at all. And I tried to argue 2477, but because the declaration of wilderness area was done before I got my argument, before the main office is down in Pueblo, I was kind of sort of put out by it. But what I'm telling you is it's important for you to look at that area body of law and see if that applies to you. There's a lot of really good papers out there that are written about how you deal with that kind of stuff. But it's RS 2477. Yes.
Mine is different from the law. Mine is not regarding BLM. It's regarding this counties or cities in the area.
Yeah.
I live in Del Norte and I have a piece of property that's very sought after, but they're constantly, community people are constantly having to put a community garden. Grant writers that want more, they want to obtain more for the, a more multi-use housing. How much does any of this apply to what I see? So, I mean, what I'm doing, oh, they wanted for a park, they wanted to get more friendly, that I'm asking, and they have to be given.
Okay, so the threat of eminent domain. Unfortunately, I have been involved in a couple of those cases, and unfortunately, they didn't go very well because the power of eminent domain is both private and public, by the way. So you could have a neighbor that wants to privately have eminent domain over you, and the public can also have an eminent domain. So I encourage you, if that is what you think is going to happen, what you need to do is to begin to study on your own what you can do to brace yourself if you're filed have eminent domain. The lot next to you, because it's not yours, I guess that's what I'm getting, is not yours. Okay.
It's just a large, but I have an old church.
Well, the other thing with 1872 is you can, if you want to preserve that church, because you got to kind of sort of take a stand. Do I want it to remain vacant? Do I want to continue to preserve it? Is Colorado has some very strong historic preservation statutes that you can appeal to protect those kinds of antiquities and stop them from taking that land. The second part of it is that you need to understand what that land use is. Because pretty much every county, even the ones down here, have pretty complete land use maps. And you need to see what that land use is so that if there is ever a petition to change that, you need to start actively participating in that.
Okay. My pins I've got my pins, I've got my survey all recorded, everything.
Good, because that is one of the biggest things is you got to know what you have.
Yeah.
I was on an eminent domain case. And one of the issues, I mean, we're at the Court of Appeals. I finally said to the lawyers out of Grand Junction, I said, did anybody ever go and look where the true entrance of this road was? No, we never did. And so I called up, went up to the rancher who was next to it, and turns out it was really on his land, not on my client's land. Hundreds of thousands of dollars in legal fees later, and no one bothered to even check that. So it's super important to understand what you have. it's super important to make sure that you understand that your entrance to your land is not on BLM or Forest Service, because you actually do need a permit for that. And to make sure that you really have a good feeling of what it is I have here. Document it, have a file on it, because when things start to happen over here, and everybody that has an interest in this, you need to be on the email list for any notifications from your local county. Every single county has a way of signing up for receiving emails on agendas, on notices, everything. And you just go right to the county site and you can be on that list. I am. I mean, I get all kinds of emails on it. Some things I respond to, some things I don't. But at least I know, and at least I have an ability to go, I think I'm going to take up on this.